So thank you all for coming this morning. Dr. Giacchini, who's sitting in the middle here, who most of you will know, and I have spent years researching victims, especially with regard to participation in criminal justice, with regard to reparation, restoration, etc., from somewhat, I think, different perspectives. So most of my work has been in the domestic legal sphere. Hers has been international, both in the International Criminal Court, at the ICTY, and also in the courts in Cambodia. And although we've come from different jurisdictional perspectives, we have shared interests and shared concerns about victims' roles in criminal justice. So the key issues for us are rather similar, and I think some of those key issues will be teased out today. So traditionally, as you know, the role of the victim, certainly when I started teaching criminology many years ago, was really restricted to that of witness or complainant. But things have changed a lot. Things started to change in domestic spheres, and that has moved on into the international arena too. And I think spearheaded not least by the International Criminal Court. So although we've had a rising tide really of victim participation in criminal justice, it remains somewhat confused, somewhat vague, and at times contested. So I think it's still ripe for serious conversations. And so the aim of the project that Redina and I developed, which was generously funded by the Economic and Social Research Council and by the University of Oxford Faculty of Law, within which the Centre for Criminology sits, and that's us, and that's where Redina and I sit, was really about partnership work with the International Criminal Court, particularly with the ICC's Office of Public Counsel for Victims and the ICC's Bar Association. And we wanted to work together to consider resources, education, training for criminal justice practitioners, to really have conversations about the role of victims that would inform legal representatives of victims, to talk about the difficulties that arise from different theoretical, jurisprudential, empirical analyses of victims' rights to participate and victims' roles, as well as looking at some of the ethical, psychological and practical problems that emerge from participation. And so this collaborative work with the court was really about bringing together academia, legal jurisprudence and practitioners at the court in an ongoing conversation which started at The Hague, well, started before The Hague, but had an event in The Hague in the spring, which the ICC were heavily involved in organising with us and participating with us, and has gone through to today. And I want to take this opportunity. I was unable to attend the event in The Hague. At the last minute, I had to pull out through family illness. And Redina heroically took over the whole thing with Jens in particular, who you'll hear from in a minute, and the other part of his team at the court, and did everything beautifully, and it all went terribly well, which shows that I'm totally redundant, which I'm quite happy about, but it also shows just how professional and organised she is, and how helpful the court were in that process. So thank you very much to them. So today is about continuing that conversation, and although the project is soon coming to an end, we hope it will lead to other collaborations. It's something that the University of Oxford and certainly the Faculty of Law are now Centre take very seriously, engagement with practitioners, engagement with those people who use the law, and thinking about their needs and their interests and their concerns as we develop research, as we do research, and certainly as we disseminate it. So I'm now going to pass over to Jens Diekman from the International Criminal Court, and he will address you before the first panel of the day begins. And there will be coffee at the break between the two panels for those who are slightly caffeine depleted. Thank you, Jens.
Thank you very much, Professor Hoyle, for this warm welcome. And yes, ladies and gentlemen, friends and colleagues, a very good morning from my side. On behalf of the International Criminal Court Bar Association's Presidency and Executive Council, I just want to say thank you. I just want to say thank you for this wonderful, trustful cooperation. It's an ultimate honor and privilege for us to be a partner over this long run in this fantastic project. When I was thinking to prepare this day, I was wondering, being a guest here at an institution working for more than 800 years, staying in a college established in 1282, what might be of interest for you to hear about an association that exists for 2 years and 3 months. So what should be necessary for you to know to understand why this project is so important for us as such a young association? Ladies and gentlemen, in England, as I learned, lawyers took over the inner and middle temple from the order of the Knights Templar, and the common bench having been established at Westminster in the late 13th century and early 14th century. So the association of lawyers performing a free profession under their own rules is an inherent part of modern history of law and lawyers, and it's a part of any modern civilized country governing under the rule of law. But ladies and gentlemen, this year we are celebrating the 20th anniversary of the Rome Statute. The Rome Statute is the founding document of the International Criminal Court. And the court starts effectively to practice in July 2002. But if you have a closer look to the Rome Statute and the rules and the regulation, you will not find a bar association, or you will not find any rules on organizing a bar association. Could you imagine states and governments having, since centuries and decades, law associations in their own national system, creating the highest international criminal court of the world without any idea how to organize lawyers who should practice there, preparing and presenting indictments, preparing massive evidence, and of course organizing a disciplinary regime. Then of course any lawyer who is working at the ICC is under a disciplinary regime. But there is no bar to defend lawyers if there is a problem. Could this be? And just a personal remark at this point. This is not just a fundamental issue or a theoretical issue, having a bar or not a bar. It is not about violation of fundamental principles. Of course it is. It's practical. For the lawyer in the courtroom under fire, without a bar giving advice and support, it's crucial. It could ruin your career. I was assigned in 2008 in the Coney admissibility proceeding, and it was the first time to be assigned at this court. And of course, if you're arriving the first time in such a court, you think in the first moment that all your dreams come true. But it took just 24 hours to realize that this is just a nightmare. That a chamber of 3 judges, a diplomat and 3 professors of law who never practiced as a judge, assign you to defend the interests of four defendants in one criminal case, which is in clear violation to any principles any civilized nation has. There were no rules, no procedures, no association who could give an advisory opinion. And the only structure that was existing in The Hague at this time was the International Bar Association. And so I want to take this opportunity this morning to welcome Lorraine Smith, who was working for the IBA office and the IBA in The Hague at this time. And this was the only institution who gave ethical advice for counsel under fire without official rules at this time. And so it was a long, long run to establish a bar. It took, in fact, 3 attempts, 2007, 8, 2012, and 13. And finally, 2016, we succeeded with very much support from the ICC presidency, who realized that it's not possible to continue with this court, who is arresting lawyers in cases like in the Bemba case without a bar defending the interest of lawyers. So here we are today. The ICCBA is an independent association. The membership is still not mandatory. We are a free association under Dutch law, in fact. And the key characteristic of the ICCBA you should be aware of is that we are representing all counsel who are working at the ICC in the definition in Article 1 of the Code of Conduct. So it means any counsel who is showing up in the courtroom and making submissions on behalf of his or her clients, defense, victims, witnesses, if you are representing a government as a counsel in an admissibility proceeding, if you are a counsel for OPCD or OPCV, and if you are on the list of counsel, you should be protected and supported by the ICC BA. We have several committees trying to cover all necessary work. We have a professional standard advisory committee, and this was exact the structure I was dreaming of 10 years ago. A hotline, an ethical hotline. If there is an issue in the courtroom, there must be someone you can talk with, and perhaps you can initiate an advisory opinion from the bar to assist you in the specific situation. And of course, ladies and gentlemen, training. Training is key. Training is key for any bar association, and it is a basic idea, a basic value of our profession, that the experience of lawyers are transferring from one generation to the other. Training from lawyers to lawyers is key. But as Professor Hampel, excellent advocacy trainer from Australia, once said in a training in The Hague, playing 30 years tennis does not make you a champion at Wimbledon. Doing something 30 years every day does not mean that you have excellency in doing this. So what's absolutely necessary for us as lawyers is to confront ourselves with new ideas, with fresh ideas, with a perspective from the outside. And here we are. And therefore, as a very young association, at the very beginning of our work, it was a perfect timing when Ina and your office contacted us, because it was a crucial moment for us to define ourselves. Because in the victims committee, we realized by ourselves that it's not victims against defense, victims against the institution. No, among us, how to discuss our approach among ourselves. And so this project offers us a unique opportunity to develop our own standards in the specific surrounding, in the specific area of international criminal law in The Hague. And I would like to take this opportunity to thank one person. Without her commitment, inspiration, and encouragement, we would not be here today. And this is Ina. And thank you very much again from the ICCBA for all your work during the last 12 months. So here we are today. I wish everyone a very inspiring and thought-provoking day. And I give over the floor to Ina. Thank you very much.
Well, thank you, Professor Hoyle and Jens, for your very kind remarks. I'm most grateful. I'm delighted and honored to have been offered an opportunity to work on a project that is very close to my intellectual interests and very close to my research. I'm grateful to you, Professor Hoyle, for your outstanding and unwavering support, not only as my supervisor for my doctorate degree, but also the support for this project. I also take the opportunity to thank and to express my sincere gratitude to the International Criminal Court Bar Association, and particularly to you, Jens, for supporting so enthusiastically this initiative from day one and for being a true partner in the implementation of this project. Victim participation is still a novelty in international criminal justice, and as such, it remains a live topic of interest among academics and practitioners alike. It is in this spirit that we are gathered here to talk about various aspects of victim participation at the International Criminal Court, but more generally, victim participation in international criminal justice, and more specifically, the issue of reparations. I have the distinct honor and pleasure to moderate the first panel of this workshop, which is on the after Bemba Acquittal, the future reparations for victims at the ICC. I'm joined by distinguished colleagues, scholars, and practitioners. Luc Wallen is an advocate at the Bar Association in Brussels since 1972. He was an NGO observer at the 1998 Rome Conference and has represented victims in the Lubanga case at the International Criminal Court since 2006. Luc also has been a guest professor of international criminal law at the university colleges Leuven-Limburg and the Université Libre de Bruxelles. Ms. Lorraine Smith-Van Lien. Lorraine joined Redress in 2017 as a post-conflict justice advisor based in The Hague. Prior to her joining Redress, Lorraine worked for over 7 years as a director of the International Bar Association's International Criminal Court program, monitoring the fairness of legal and policy developments at the court. She has worked as a consultant on international criminal justice and human rights issues. A national of Jamaica, Lorraine has practical experience working directly with victims for several years as a prosecutor and resident magistrate in Jamaica. Her concerns about the inadequacy of the legal framework for addressing the needs of victims of crime in her country led to the pursuit of an LLM in international human rights law at the University of Essex in the UK. And her current focus is on the post-conflict countries in Africa, including Uganda, where she's working to ensure effective participation of victims in transitional justice contexts. Peter Haynes QC is a British barrister with more than 30 years' experience, a former colleague of mine at the International Criminal Tribunal for the former Yugoslavia. He has acted as the lead counsel for Jean-Pierre Bemba at the International Criminal Court between 2010 and 2018, famously securing his complete acquittal on appeal. He is the lead legal representative of victims at the Special Tribunal for Lebanon and is one of the very few legal practitioners who have led cases before the International Criminal Tribunal for the former Yugoslavia, the International Criminal Court, and the Special Tribunal for Lebanon. He has appeared in cases involving genocide, war crimes, crimes against humanity, and international terrorism. He has been responsible for the development of jurisprudence, practice in international criminal law. But Peter comes from a distinguished career as a barrister working on domestic cases in the UK, including, among others, the cases of murder, complex conspiracies, sexual offenses, human trafficking. He is engaged as lead counsel currently in a class action against the British government concerning the torture of prisoners in Cyprus. Peter also works as an independent consultant on international criminal law matters, advising both governments and head of states. He advised the Dutch police in relation to the shooting down of MH17 and was part of the commission which reported on the promotion of restorative justice in Sri Lanka. He regularly lectures and speaks on the topics of the function of international criminal courts and victim representation. And lastly, Dr. Carla Firstman. Carla is a senior lecturer at the University of Essex School of Law and the former director of Redress. She has worked in the human rights field for the bulk of her career to date. After having practiced in Canada as a criminal defense lawyer, she began working internationally, first for the United Nations High Commissioner for Human Rights in Rwanda. Thereafter, she joined the International Secretariat of Amnesty International in London on a special initiative on trials in the Great Lakes region of Central Africa, including, among others, work in Burundi, Democratic Republic of Congo, as well as the International Criminal Tribunal for Rwanda. Furthermore, she moved to Sarajevo, where she was appointed as the executive legal advisor of the Commission for Real Property Claims of Refugees and Displaced Persons in Bosnia and Herzegovina. Carla joined in Redress, the award-winning non-governmental human rights organization which pursues justice on behalf of victims of torture, in 2001. First as a legal director and later as the main director of the institution. During her tenure at Redress, Redress as an association and non-governmental organization won the MacArthur Foundation Award for Creative and Effective Institutions. She has published extensively and is a regular commentator on an array of human rights issues, and she is a member of various boards and committees related to international criminal justice. She is also a graduate of Oxford University and of Mansfield College with a doctorate degree in law. Without further ado, I would like to invite Luc to talk about collective reparations of model for the ICC. Perhaps, before I forget, I would like to make you aware that this workshop and all the panel discussions are being recorded, and the podcast web link will be uploaded on the event page at Oxford University as well as the ICCBA website. I'm sure the panelists have given their consent already for the recording. Luc, the floor is yours. Thank you.
Okay, thank you, Elena. I will stand up, it's maybe more easy. We will talk today on the future of reparations at the ICC, but before coming to the future, maybe we should also have some thoughts on the past. It's a past of 20 years, and when the diplomatic conference in Rome adopted Rome Statutes, the multiple NGO observers who were active during the conference were very happy, of course, with the establishment of the first permanent international criminal court, but in particular also because they could achieve with an intense lobbying some very important progress, what was seen as a very important progress for victims and victims groups of mass crimes, which is the fact that they can participate in the criminal procedure, express their views and concerns, and also claim reparations. And on top, taking into account that most convicted for mass crimes are convicted for a long prison term and have not necessarily important assets to compensate victims. There was also a trust fund for victims created with an independent status, but linked to the court with the function to assist victims in the country where a situation occurs under the jurisdiction of the court, but also to organize and implement reparations when in certain cases where a reparation is not just an individual issue between the accused or the convicted person and the individual victim. So these achievements reflect in the Rome Statute, in the rules of procedure and evidences, and also in the regulations of this trust fund for victims. 20 years later, we cannot say honestly that the balance of this victim participation is only is only positive. The objective was to avoid frustration of victims, like was the case in the Rwanda International Tribunal or the Rwandese Tribunal, where the victims had only a place as witness of the prosecutor, but could not really bring in the procedure their own view on the case. I would say that in a lot of cases, the participation of victims was an important element in the procedure. Victims could bring in some particular aspects that were not brought in necessarily by the prosecutor's office. When it comes to reparations, until now, almost in all cases where a conviction occurred, the victims are more frustrated about the development of the procedure, and there is even in the best cases, we are only at the very beginning of the implementation of a reparation program. I had the privilege to represent victims in the very first case at the ICC, the Lubanga case. Lubanga was arrested in March 2006, and I and my colleague were appointed in May, I think, 2 months later, and our small group of victims accepted as participants. So it's almost unbelievable that I'm representing these people since 12, almost 13 years. It took 3 years. It took our first 3 years before the actual trial started. It took 3 years before there was a guilty conviction and a first order for reparation on 7 August 2012. The final order for reparations, which is still not final because there is a pending appeal procedure, came in 5 years later. So the principles for reparation were established in 2012, confirmed by the Appeals Chamber 2014. And the trial chamber, who was supposed to monitor, took 4 years more to finally decide upon the award for reparation, the amount that was considered as being the responsibility of the accused, but also took the initiative to decide upon hundreds of already available cases of individual victims, notwithstanding the fact that from the very first beginning, the decision was made by the Trial Chamber 1 in 2012 and confirmed by the Appeals Chamber that there would be no individual reparation progress, that there would be no individual claims for reparation, but only a program to be elaborated by the Trust Fund for Collective Reparations, implemented by the Trust Fund, and a offer-based reparation process. You should know that when we come to the legal framework, the statute, the rules, and the regulations are not an example of clarity. And the result is that the judges have it very difficult to have a common approach on this issue. We can even say that there is very often a real conflicting approach, in particular between the Appeals Chamber Appeals Chamber's view on reparations and the view of some chambers. I should not lose this, I guess. Sorry. The Rome Statute only established a general principle that reparations can be ordered against the convicted person and that there will be a trust fund. The regulations the rules of procedure and evidence went more in detail, and Rule 94 established as principle that reparations are accorded on request of individual victims that can make an individual application and obtain an individual award for reparations. Even Rule 95 says even if there's no application yet, the court can take the initiative to organize a procedure of individual claims, can announce that every victim can make a claim to the court, and when these claims are made, we return to the general rule of Rule 94 for an individual assessment of it. But there is also an article concerning the trust fund. When it comes to individual reparations, in the system of the rules of procedure, there is no intervention of the trust fund. The trust fund comes in Article 92 in two ways. There can be a procedure where the trust fund receives a global amount from the accused and organizes itself individual reparations. That's Rule 98.2. But of course, it's never occurred until now that there was an important amount available with the convicted person. There was an expectation, of course, that it would be the case in Bemba. But if Bemba had been convicted, we could have had such a procedure where Bemba is convicted to an amount of X million euro, that this amount already seized probably by the registry or to be seized also in the future with the cooperation of states, is put at the disposal of the trust fund for the organization of individual reparations. But there is also a provision in 98.3 saying that if it is not possible or very difficult to identify all individual victims, or if the individual reparations are not preferable, if it is preferable to have a collective reparation, the trust fund can organize a collective reparation program. When you look to the regulations of the trust fund, when we are in the situation of, I would say, mixed reparations, I mean, the trust fund has a global amount but organizes individual reparations, it's up to the Secretariat of the Trust Fund to decide, to verify that only that the people who identify themselves to the trust fund belongs indeed to the group of victimized persons, which is a very soft provision and which involves not at all, of course, the defense. The defense in the philosophy of the drafters of all those texts intervenes only, and it's logical, when there is an individual claim to an individual accused, and whereas in a classical civil procedure, the court has to see if there are sufficient evidences about the situation, about the prejudice, the harm, and about the relationship between the harm and the crime that has been condemned. There is no space in all those texts for defense intervention in a collective procedure unless there is a general provision that any form of reparation should respect the rights of the defense. So what are the rights of the defense in such a collective procedure? That's of course not determined, and that's to be determined by the court. In my view, the rights of the defense doesn't mean that in a collective reparation program, every individual convicted for crimes linked to this reparation program should have a view on any individual beneficiary. Historically, collective reparation programs, be it in Germany or Colombia or else, are essentially administrative procedures, perhaps monitored maybe by a court, if it is in the framework of a court that such a reparation program is set up. But the view of the defense, the input of the defense, if there is any input, is on the general concept of a reparation program, and of course not on the individual beneficiaries. It would have been not imaginable that Alfred Speer would have a view on any individual request for compensation from survivors of the Holocaust. Of course, it would have been an absurd situation, but in a certain sense, that's what's happening in some cases in the court. So in the Lubanga case, we had it went to a climax in a certain sense, where the chamber, a new chamber, not the chamber who handled the criminal case, where the chamber responsible to monitor the reparation program rejected the reparation plan or suspended the reparation plan presented by the trust fund, saying that such a reparation plan could only be accepted once the trust fund could identify all victims of the case and make an assessment on the individual harm of all this, which is a complete impossible task. The trust fund tried to appeal, it was not accepted. The chamber moderated somehow the decision, saying that, okay, we need at least a representative monster of potential beneficiaries. What we need to determine the amount for which the convicted person will be responsible. So the trust fund started with the participating victims and stopped the exercise after 2 weeks, because making an assessment of harm in the framework of a judicial procedure means, yes, that you cannot decide in 10 minutes on the quality of victim of a case. So all potential beneficiaries interviewed by the trust fund were also submitted to a test by a medical doctor and a psychologist and a social assistant to make a report on their eventual presence of psychological trauma in relation with the harm suffered, and also on the possibilities of reparation for each individual from a social economic point of view, or at least also to see what have been the socio-economical result of the crimes. You know, I guess, that the Lubanga case was a case where the accused was prosecuted for recruitment of child soldiers. In a second step, when the trust fund refused to continue, OPCV was appointed with a parallel mandate not to make an assessment, because the assessment, of course, is not to be made by the counsel of a victim, but to identify, to prepare a dossier, a case file about identified victims to be presented to the registry, and to, in the view of an assessment by the chamber itself. The final result was that the chamber made an individual assessment of 470 and so on victims, making a mix between those who had been through an assessment procedure of the trust fund and those who had not been through such an assessment procedure. In fact, the court just put aside the assessment procedure of the fund, and so provocating a useless expense of more than $200,000, I think, only for this exercise spent by the trust fund, and rejected half of the participating victims that had been accepted by the trust fund, because, and that's also the problem that will be discussed in the other session, mainly because of contradictions between applications made 12 years ago, not by those former child soldiers who were still underage at the time, but applications made by their parents, their uncle, some other family members, made by intermediaries of NGOs, and indeed signed or with a term signed from the victim. But when the officer of the trust fund made an interview and a report of the story told by the victim 12 years later, of course, both forms were not identical, and it was easy for the legal assistance of the court to discover that there were some contradictions on dates, on etc. Notwithstanding the fact that even on these individual contradictions, there had been a discussion in the framework of the assessment of the trust fund. So there were, in any case, discussions on that, and accepted by the trust fund, but also discussion with the defense and an answer to the defense observations. So that's the situation now in the Lubanga case, where there will be a quite interesting hearing probably on 17th October. I know that I have to finish. Just to say that there were two other cases where reparations have been decided. In the Katanga case, started with individual claims made by the victims, but the court decided finally that there would be essentially a collective reparation program, with the only exception that an amount of symbolic reparation of $250 would be given to each individual victim. In fact, this symbolic reparation becomes, for most of the victims, the most real, tangible reparation until now. In the Almaty case, that was a case of destruction of buildings, mosques, by Daesh. Actually, the reparation of the buildings was already made by UNESCO, so the court decided to order individual and collective reparations to people around these buildings, imams, but also pilgrims and business people who are selling souvenirs and so on, whatever. So how could we in the future avoid such situations? In my view, one of the problems is that the court is mixing up systematically the decision on the responsibility for reparations of the convicted person and the rights of the victims in the framework of a collective reparation program. In fact, it's very well possible when someone is convicted, and it's also provided for in the text that a reparation award can be decided upon global inquiries on the harm, on the collective harm that has been suffered. There can be expertises, there can be other sources to prove that what kind of harm had been provoked, and of course the exact amount. There is no exact amount. The amount, and that was stressed by the appeals chamber, the amount of an award for reparation is the cost of the reparation. There is no objective cost of the death of some person. The reparation of this debt will depend on the decision of the court. If a court says for us that person is worth $400, the price for the cost of reparation is $400. If the case of the court is that it's $1 million for if you lose your husband, then of course the cost of reparation is $1 million. So, but that's not the way the courts worked until now. So that's the first thing. We have to split it, decide upon the responsibility of the accused, of the convicted, and then set aside the convicted and the defense to organize a reparation program with the trust fund in the philosophy of the text. And second thing, the trust funds, in my view, should not wait until the final decision on appeal on the reparation program before starting reparations. The trust funds makes a strict distinction between its assistance mandate and reparation mandate. In fact, if you are constructing a building that has been destroyed in the framework of an assistance program or in the framework of a reparation program, the practical result will be the same. So it's only a linguistic distinction. So if the trust fund starts early the reparations, a lot of problems could be avoided. And if there is then at the end an acquittal of the accused, we would not have the same reparation as has been the case now with Bemba, because the victimization was real, was not contested by the court, and if it had been repaired, whatever the sanction for the responsible, it would not have changed. So, thank you. Sorry to be too long.
Thank you, Luke, for highlighting precisely the limitations that comes with the way in which the ICC has implemented the victim participation scheme, particularly with a very decentralized system where you have different situations and different cases within a situation. So the need for common standard and cohesive approach to reparation, it's paramount, in my view, at the ICC. 13 years is indeed a very long journey for any victim subjected to gross violations of human rights to wait for a rather symbolic reparations and nothing meaningful in terms of individual or financial reparations. To further our conversations with regard to the limitations at the ICC in terms of reparations, I will invite Lorraine, who is going to talk about wake-up call, opportunities and challenges in ensuring reparations for ICC victims post-acquittal in the Bemba case. Thank you, Lorraine.
Thank you very much, and good morning to everyone. I'd like to thank the organizers of this event for the kind invitation. I think it is, in fact, a privilege and an honor to address such an august audience on what I consider to be a tremendously important issue, and that is the right of victims to reparations. As Radina said in her introduction, I come from a very different place. I come from a country that is based on a common law system and where the centrality of victims' rights are not so obvious in the procedures in our courts, and certainly there is no right per se to reparations unless you're going to proceed in the context of a civil court. I work for Redress, and Redress is an organization, and much has been said, so I won't say very much at this stage, about Redress's tremendous work as led by Carla then and led by our new director, Rupert Skilbeck, tremendous work in trying to advocate for the rights of victims of torture and other gross international violations, to ensure that they have justice, to help in setting standards governing the rights of victims. So it is somewhat, I say it very humbly, that I am sitting amongst the best of the best in terms of looking at these issues, because I joined Redress only last year. So you would forgive me if I'm not able to say as much as the others on some of the issues that have happened at the ICC. One thing I can assure you is that my passion is no less. And it is good that I precede Peter, because I know that he probably has even greater passion than me on some of these issues. I want to speak to you today about Bemba and what the possibilities are after the acquittal in the Bemba case. I believe that the Bemba case provides a tremendous opportunity for reflection on where the ICC now stands in relation to the rights of victims. As Luke said, it might be interesting to look ahead, but we also have to look back. And I say look back at what the normative framework is of the ICC and where it is in the context of the broader international understanding about victims' rights to reparations. So with that in mind, I would wish to argue in this discussion that there are significant limitations in the reparations scheme at the ICC, because it is based on a principle of individual criminal responsibility. However, despite the fact that the provision of reparations is one of the rights afforded to victims, The award of reparations is contingent on the conviction of an accused person and not on the responsibility of states. And this implies, in my view, that reparations will necessarily depend on the nature and scope of the charges against the accused, the strength of the evidence, and on judicial discretion, variables which provide very little by way of guarantees. This paper will explore whether there are possibilities for ensuring reparative justice for victims, despite the limitations of a case-based reparations process. I argue that there are several lessons that the court and the Trust Fund for Victims and states can and should learn in relation to making the procedure more efficient, managing victims' expectations, and assisting victims in the interim, which would greatly help to mitigate much of the disappointments which flow from an adverse decision. One of the major innovations of the Rome Statute, as has been said, is the right of victims to participate in proceedings, not only as prosecution witnesses, but as independent participants with an interest in the outcome. And this, we know, is provided by Article 68(3), which allows victims to participate at different stages determined to be appropriate, where their personal interests are affected in a manner which is not prejudicial or inconsistent with the rights of the accused and a fair and impartial trial. Article 75 is the legal basis for reparations to victims. The provisions adopted at the Rome Conference, however, only provided a very basic conceptual framework for reparations, leaving fundamental principles to be determined elsewhere. And just so that we contextualize everything, Article 75(1) makes it very clear that the court shall establish principles relating to reparations to or in respect of victims, including, and I would add not limited to, restitution, compensation, and rehabilitation. And on this basis, in its decision, the court may, either upon request or on its own motion, in exceptional circumstances, determine the scope and extent of damage, loss, injury of victims, and will state the principles upon which it is acting. Now, the court opted, despite several recommendations, not to initially have general principles governing reparations, but decided to adopt a case-by-case approach. The general right to reparations is a well-established principle of international law, both in terms of states inter se as well as for individual victims. And the ICC is required by virtue of Article 21(3) of the statute to interpret its provisions in a manner that is consistent with internationally recognized human rights, which necessarily, we would argue, include the Declaration of Basic Principles of Justice for Victims of Crime and Abuse of Power, and the basic principles and guidelines on the right to a remedy and reparation for victims of gross violations of international human rights and humanitarian law. But as I have indicated several times, it is based on a principle of individual criminal responsibility, which necessarily implies that there are real limitations in the number of victims who can and will actually be able to benefit from ICC reparations for several reasons. First, the charging practices of the Office of the Prosecutor limit the type of victims who can benefit based on the crimes charged, geographical focus, which side of the conflict the accused was on, for example. Secondly, the conviction or acquittal may further limit the types of victims who can actually benefit, or may exclude certain types of victims. For example, if there was insufficient evidence to prove a particular type of crime or incident, or there is a legal ruling excluding certain types of crimes. Third, certain types of harm may be excluded from the reparations order itself. Example, for lack of proof that a particular type of harm had a causal connection with the crime, as occurred in Katanga with physical harm. Thus, there is a real tension between, and I put this in quotes, the aspirational aims of the statute to ensure reparative justice for victims and the practical limitations of a scheme based on individual criminal responsibility. And now to the Bemba case. By way of background, we know that Mr. Bemba was convicted in March 2006 by the trial chamber under Article 28A of the statute as a person effectively acting as a military commander of the crimes of murder and rape as crimes against humanity, murder, rape, and pillage as war crimes. Following his conviction and sentence, and while the appeals were in respect of the conviction and sentence were pending, the trial chamber made an order, and you will, when I say trial chamber, please understand that there were changes in the composition of the trial chambers. The trial chamber made an order requesting submissions relevant to reparations. The chamber also ordered the registry to provide a list of experts to assist the chamber in the reparations proceedings. The defense objected, arguing that this would be premature, and requested the chamber to refrain from instructing expert witnesses and to suspend the reparations process at the latest until after the selection of any experts and the finalization of any letter of instruction. The defense argued that beginning the reparations process prior to the determination of the appeal was inconsistent with the rights of the accused, as it operates as an effective presumption of guilt and would place a burden on the defense's limited resources. Both the prosecution and the legal representatives invited the chamber to reject the defense's request, claiming that the pending appeal had no impact on the reparations proceedings according to the prior practice of the court. They contended that the reparations proceedings were not prejudicial to Mr. Bemba's rights, but would negatively impact the expeditiousness of the proceedings and the victim's timely access to reparations. And to move a bit more quickly, we know that the chamber nevertheless proceeded to go ahead with the preparations for reparations. But on the 8th of June, the appeals chamber by majority reversed Mr. Bemba's conviction, discontinuing the proceedings in relation to certain crimes and acquitting him of all remaining charges brought against him. By the 13th of June, Trial Chamber 2, which had been considering the issue of reparations, requested the parties to file submissions concerning the effect of the appeals chamber judgment on the reparations proceedings. So the reparations proceedings, which had commenced prior to the appeal decision, was discontinued. And the judges made it very clear then in their final decision that the limitations of the ICC's reparations scheme meant that they were not able to issue a reparations decision in light of the acquittal of the accused, because it is based on the principle of individual criminal responsibility. But the decision raised other issues which I would invite you today to consider. Broader questions, I would say, on the timing and nature of reparations proceedings and the role of the chamber, or I should say better put, on the effect of decisions by the chambers if, in the event of an acquittal, if reparations proceedings were commenced prior to an appeal. On its face, the outcome of the appeal would appear to vindicate the defense's submissions that reparations proceedings commenced prior to a final outcome on appeal is premature and inefficient, particularly if the conviction is overturned. However, there is strong argument, and this was made in the submissions of the legal representatives for victims and the prosecution, that commencement of reparations proceedings prior to any eventual appellate decision is ultimately more efficient given the number of procedural steps, interim measures, and decisions a chamber has to make, which will effectively make them quite lengthy. Given that trials are invariably protracted, a further protracted reparations phase does not take account of victims' needs. As the prosecution noted, notwithstanding pending appellate proceedings, a trial chamber is not barred from taking interim steps with a view to issuing a reparations order and eventually doing so, given that Article 81.4, under Article 81.4, only the execution of a reparations order must be suspended pending the appeals confirmation, the appeals chamber's confirmation of the conviction decision. Effectively, the prosecution and the legal representatives were arguing that from an efficiency perspective, given the protracted nature of trials, it made sense for there to be a reparations process before a final decision on appeal. But we have, and we just concluded 2 days of roundtable meetings with stakeholders on reparations. And there are now, from my understanding from some of the interventions, real questions about the timing of the reparations process. Should a court make a final reparations order before the conviction or sentence is affirmed on appeal, or an appeal decision is made? These are real questions. I would submit that given that a number of ICC trials, with the exception of Almadi because of its specific nature, tend to take on average, I would say, between certainly more than 5 years. If one were to wait for an appeals process, which is in itself also protracted, then you are adding another layer, and there are two possible outcomes. Well, there are several possible outcomes to an appeal, but certainly the confirmation of the conviction is one of them. And if one has to then wait until after this to begin some of the procedural steps necessary, again, issues arise as to whether we are looking at the broader sort of reparative aims of the statute and how this would impact victims. A practical example, a number of the legal representatives who we have spoken to made it very clear that irrespective of the outcome of the process, some of the victims in the case have either died because they were HIV positive because of the attacks that were inflicted on them, or they have suffered tremendously. I wouldn't go into any detail. Paulina is here and can speak to the issue herself as she represented the victims in the Bemba case. But the question of, it's not, in our view, just a matter of strict procedure. It is a question at looking at the broader overarching framework of the statute in terms of meeting victims' needs. The question is the solution in starting earlier just a procedural issue, or does this have any kind of benefit for victims? Please feel free to tell me when I have only 2 minutes. I just have a few more points. Two, I will wrap up very quickly. The decision also raises interesting questions about the utility of decisions of the chambers. The legal representatives for the victims invited the chambers to issue principles that could provide guidance to future reparations proceedings and to make a finding concerning the scope of victimization. The chamber declined to do both. Broader questions.
It was inappropriate. Which I honestly think it's different. So.
Yes, no, and thank you for that correction, Paulina, because they used the word inappropriate, that it was inappropriate to do so. And it leads me, and it would be an interesting discussion, what does that mean? Has the chamber failed to consider whether or not there are potential opportunities that could be afforded from having that finding? For example, if there are civil proceedings at the national level, what could potentially be the value of any findings by an ICC chamber in respect of proceedings outside of the ICC? These are issues to consider. And so in my last minute, I have 3 suggestions in terms of, given the limitations of the reparations process and the broader reparative justice aims, what more can and should be done to ensure that victims obtain justice. One suggestion is that the court and the trust fund, and Luke kindly said it in his presentation, should look more holistically at reparations and begin earlier. So, for example, as Luke mentioned, use the assistance mandate early. It's commendable that the trust fund jumped in at the end and said we will step in to help the victims by going into the Central African Republic with the assistance mandate. We are saying that the trust fund could have been more strategic and start the process earlier. The second suggestion is the registry and the trust fund should develop a clear outreach and public information strategy on reparations to help with informing, not just managing, because managing sounds a bit paternalistic, informing victims' expectations. And legal representative of victims should also engage proactively with their clients on this issue quite early. In the Kenya situation, the registry took a proactive role in mapping victims to establish an outreach strategy at the early stage of the case. Victim mapping can also be done earlier in relation to all situation countries at the initial stages of the court's work. The Bemba case is a lesson for the court in starting early on reparations, helping to manage expectations, preparing victims adequately, and preparing the message so everyone involved is clear. And I will end with this. The decision is also a wake-up call, I would say, for all stakeholders that the ICC, while central to the process of obtaining reparations for victims, is not the only mechanism available to victims. And we have to begin to look at what is then available to victims outside of the framework of the ICC. And for this, I would invite us all to consider the pressure that needs to be brought on states to remind them that within the framework of complementarity that the ICC is based on, states have the overarching responsibility to ensure reparations for their citizens. And I don't have time to get into why this is particularly challenging in post-conflict context, but I believe it is still a discussion worth having. Thank you very much for your time.
Thank you, Lorraine, for this very insightful outline of the issues of reparations in the Bemba case. And what better way to proceed with Peter, who is responsible for acquitting the man himself. Thanks.
Well, it's Act 3, and that's when Shakespeare normally introduces the villain. I've got some pictures for you, actually, if I can find them. That's it.
This one?
Yeah. I'm not actually sure whether the villain is him or me, but we're both symbolically dressed in black. But of course, I've got two perspectives on this. During the past 8 years, I have, whether through good or ill fortune, I don't know, been engaged concurrently in 2 international criminal cases in which victims of crime have been permitted to participate. Firstly, and obviously of most relevant concern today, at the ICC as Defence Counsel for Jean-Pierre Bemba, but also concurrently at the STL as lead legal representative of victims. And I've been able to see victims' representation from both ends of the kaleidoscope. I've seen its good and not so good aspects and formed views as to where it should go in the future. And I think they're going to be consonant with a lot of what you've already heard. Before, however, I launch into my manifesto, let me begin by getting a few things off my chest about the acquittal of Jean-Pierre Bemba, about which I have endeavoured to maintain a dignified silence these last few months. I've been a practicing lawyer for 35 years. I have been involved in high-profile cases, both domestically and internationally, throughout that period, and especially during the last 19 years in The Hague. There has to be a decision in such cases, and those decisions will inevitably result in joy and disappointment in equal measure. As professionals, we learn to accept the slings and arrows of outrageous fortune, as Shakespeare termed it, digest our mistakes, learn from them, and move on. The fallout from the appeals chamber decision in the Bemba case, however, was something else. The lines of division were immediately apparent within moments of the decision in the very precincts of the ICC building. In the ensuing weeks, many commentators took to social media, criticising and bemoaning the decision on the one side, welcoming it and lauding it on the other. There are no prizes for guessing which side of the debate I fall on, but I'm not here today to defend the judgment. Indeed, in many ways, it was a disappointment, a missed opportunity. Those of us who were waiting for the Tadic of the ICC will have to wait probably for a very long time. We're still in the dark about the propriety of ex parte contact with a trial chamber concerning the merits of a case, interference with privileged communications between accused and their lawyers, the proper ambit of victim participation during a trial, how contextual elements of crimes against humanity are proved, and whether causation is an element of Article 28 liability or not. However, there are lessons to be learned from the Bemba case, some of which don't arise directly from the Appeals Chamber's judgment. Some do, and it would be short-sighted to ignore them. The judgment is part of the ICC's jurisprudence now. In some respects, it may be peculiar to its facts, in others not, but it's there, and we will all have to live with it in the future. I've attempted to identify some of the key lessons learned from the Bemba case, in particular in regard to victim participation and reparations. I will necessarily, given time constraints, have to run through them in little more than bullet point form. But before I do that, I just wanted to make 3 short points. Firstly, the implicit criticism of the fact that the Appeals Chamber arrived at its decision by a majority seems to me to be entirely misconceived. Majority decisions lie at the very heart of democracy. Governments are elected, referenda won or lost, and laws passed by simple majority. Many landmark decisions of appeals courts all over the world have been decided by a majority. The UK Supreme Court decision on Brexit was by a majority of 8-3. Miranda in Arizona, 5-4. The upholding of the Muslim travel ban by the United States Supreme Court, again 5-4. The issuance of separate opinions, moreover, indicates engagement by all the judges in the issues before them, rather than the simple rubber stamping of perhaps just one. Secondly, the evidence in the Bemba case was extremely poor, especially on the key issues of command and crimes against humanity. Mr. Bemba wasn't originally charged as a commander. The Office of the Prosecutor only resorted to Article 28 when it was suggested by the pre-trial chamber in its rejection of charges under Article 25. In order to make the evidence fit the mode of liability, the prosecution jettisoned all evidence of the command chain, relying instead on victims and hangers-on to prove the elements of command. This was a unique and forlorn endeavour. As to the contextual elements of crimes against humanity, the misgivings of the appeals chamber were obvious, especially in the oral arguments, where prosecution advocates were pressed by the bench to agree that nothing plus nothing equals nothing. Thirdly, the Bemba trial judgment was of extremely poor quality. The citations to evidence were substantially erroneous. The trial chamber misappreciated the burden and standard of proof, ignored relevant evidence, mischaracterized evidence, and drew inferences without any proper basis. All 3 of the majority were of that opinion. Indeed, the President, in concurring with Judges Morrison and van der Weingart, stated that there was so much more wrong with the factual findings than even they had identified. The mantra chanted by current and former members of the Office of the Prosecution Staff that the lack of deference to the trial chamber's findings was a novel departure in law masks a truly worrying assertion, namely that trial chambers of the International Criminal Court are there to convict in spite of the evidence, confident that appellate review is little more than a rubber stamp process of confirmation of their findings. Thus, expressions of surprise at the appeals chamber's decision from those looking in from the outside are water off a duck's back to me. I lived this case for 8 years, saw the witnesses, read the evidence, and pored over the trial judgment. It was a rotten case from the outset, a fact glossed over by a rotten trial judgment. Ultimately, thanks to the integrity of the majority of the appeals chamber, it got what rotten cases deserve. However, nobody, least of all me, would deny that people were victims of the civil war in the Central African Republic in 2002 and 2003, just as there have been victims of the civil wars in that country in the subsequent years. Bemba's acquittal was a disappointing blow to them. Undoubtedly, they had been led to believe that his conviction would materially improve their lives. Now, the offer of $1 million from the Trust Fund for Victims aside, it appears they will receive nothing. The situation is truly unfortunate. We are all agreed it shouldn't happen again. The institutional response is troubling. It seems to suggest that all that needs to be done is to ensure that everybody is convicted in the future. However, the International Criminal Court's current track record doesn't make that a safe bet. Rather, it would be better to look at how more effective participation at trial can be achieved and how better to deliver prompt and meaningful reparations to victims. This can be done, in my view, through a combination of minor legislative and regulatory changes and a shift in practices. Now let's see if I can move this on. Oh yes. These are the steps which I think you'll find are largely covered by what we've already heard, I think need to be taken to improve things. Firstly, as both Luke and Lorraine have said, we need to untether reparations from the conviction. Secondly, we need the Trust Fund for Victims to start work on reparations as soon as the situation arises. Thirdly, trial participation needs to conform to the statute and rules. A sub-paragraph of that would be, we need to limit the number of participants. We need to manage victims' expectations. We need to more closely define the role of the legal representative of victims. And lastly, something that's probably acutely within my own knowledge, we need to impose duties on the registry properly to manage frozen assets. I think much of this has already been covered, but why now does it seem almost inevitable that we need to untether reparations from the convictions? Well, firstly, as I think both of my predecessors have said, it removes unnecessary technical nuances. In all cases to date, an analysis of the harm suffered, as it were, holistically by societies that were subject to wars in which crimes against humanity or war crimes were committed would have revealed harm that extended beyond those crimes charged in the indictment. It would have revealed harms to the infrastructure of society, harms not as a result of people being recruited as child soldiers, but rather that they had been raped or assaulted. These matters would not be covered by a reparations order linked directly to the conviction. So by untethering the reparations process from the conviction process, we thereby allow the trust fund to assess reparations on a wider basis. The second reason that it removes delay in delivering reparations perhaps needs no more to be said. The events in the Bemba case took place in 2002 and 2003. 16 years later, the devastating blow was delivered that there would be no reparations. Far better in my view, to get things going as soon as a situation develops and allow the trust fund to develop a reparations strategy. Of course, it avoids the disappointment of acquittal. The reparations process will take place whether or not an accused is convicted in whole, in part, or not at all. It ignores, as it were, the partisan nature of a criminal trial and compensates those who may have been the victim of harms not committed by the convict or his subordinates. And it doesn't prejudice the liability of the accused to pay. It just means that reparations is assessed in advance and his liability to contribute towards them, can be linked to his convictions. And lastly, something which was mentioned by the Appeals Chamber in determining that they would not order a retrial in the Bemba case, it removes the pressure on chambers to convict and enables them to approach their judicial task properly and without thought of the victims in the back of their minds. This probably needs very little to be said. It's already been addressed by Lorraine, I think. The TFV needs to get going as soon as a situation is identified. One of the things that was obvious in the Bemba case was that even if the conviction had been upheld, the logistics of implementing reparations would have taken many, many years from now. The infrastructure in the Central African Republic was desperate. There were probably only two organisations with which a partnership could be built, the ICRC and one which I probably can't mention because it was all the subject of confidential filings. But you need to build those sort of partnerships. And as Lorraine said, you need to build partnership with national governments to get them to contribute. You need to find other fundraisers. But this needs to happen from the get-go. This is something that's very peculiar, well, it's important to me. At the Special Tribunal for Lebanon, I had 72 clients. I knew them all. I'd had lunch and dinner with them all. They all knew me by name. I saw them several times a year. We had great communications. I genuinely don't believe that you can effectively represent victims in a trial when you have thousands and thousands of clients. You cannot possibly have their instructions. You cannot possibly have a sensible system of communication with them. And I do not believe that all those people actually want to participate in the trial. What they want is reparations. And what has happened at the ICC is that two separate systems, two separate regimes have been conflated. There is a regime for participation under Rule 89, and there's a regime for reparations under Rule 94. And if you look at the regulations that go with them, they set you off down different paths. I would advocate either that you stick to the time limit, which is that no application to participate after the commencement of the trial is admitted should be adhered to, or that within the flexibility that rules 89, 90, and 91 permit, that the chamber should set a limit to the number of victims who actually participate in the trial. This could actually make for way more effective victim participation because the legal representative of victims could effectively have a pyramid structure of communications. He or she could pick a victim in every geographical area affected by the crimes, a victim affected by each of the individual crimes charged, and use that pyramid as a means of communication to the wider group of victims. The number of victims who participated in the trial would never prejudice the number who were entitled to reparations, whose applications under Rule 94 the registrar would always be obliged to retain. Okay, I see Ina getting antsy, but this is also very personal to me. The role of the legal representative of victims at the STL is pretty heavily proscribed. counsel is subject to at least 4 written sets of obligations. They are his legal services contract, the victim's legal aid policy, the code of conduct, and the directive on legal representation of victims. I don't believe there is such a detailed system at the ICC. I'll give you an example of the sort of obligations that are imposed on counsel at the STL. You have an obligation to keep and retain up-to-date details of all of your clients, their whereabouts and contact details. You have an obligation to keep a record available for inspection by the registrar of all your contacts with your client. And we achieved that at the STL through a number of means. We set up a website which was secure, which all the victims could access. We had WhatsApp groups. They had all of our telephone numbers. We had visits to the Lebanon regularly, and we brought them to the court in The Hague. You also have an obligation to present the victim's views and concerns, and we went about that at the STL by collecting witness statements, admissible witness statements from all of them. We called some of them to give evidence, the rest we admitted under Rules 154 and 155 of the STL rules. We employed a victimologist to interview all of the victims several times over a 3-year period, whose report was admitted into evidence and reflected not just the injuries and the harms they'd suffered, but also their reaction to the process they were going, their expectations of the court, their hopes and their wishes on reparations. It was truly a masterpiece. I don't mean to be unkind, but I don't believe anything like that was done in the Bemba case. As a simple statistic, it's often thrown out there that there were 5,229 victims in the Bemba case. The final filing to which Lorraine referred this morning revealed that the legal representative of victims had contact with 563 of them. That's a little less than 11%. And I'm afraid that communication for me is the basic de minimis requirement of victim participation. And I think when you've lost contact with nearly 90% of your client base, you're not really fulfilling your mandate. Now, I'd be the first to agree that circumstances in the Central African Republic were challenging, but nobody said it was going to be easy. Circumstances in Kenya were doubtless challenging too, and in Uganda and in the Congo. But it seems to me that counsel who appear as legal representative of victims are paid a lot of money, and they need to be held to account. They need to be made to keep contact records, made to fulfill basic duties. As to the presentation of a case, well, as I recall, 2 witnesses were called. Witness statements were taken from them very late in the day. Much of the presentation of the victim's case in the Bemba trial amounted to attacking Mr. Bemba and mounting a defence of President Bozize, and I don't seriously believe that that conformed to representing the views and concerns of the victims. And I think that in the future there should be closer regulation of what is required of counsel. And I hesitate to add this. In other cases, people like Luke Willane and Fergal Gaynor, Megan Hurst, excellent counsel have been employed. Paulina herself I know to be an excellent practitioner and somebody who fulfills that mandate fully and properly, but it needs to be monitored and it needs to be done properly. Lastly, I'm sorry to have overrun my time, but I thought you'd like to hear about this. I know this is a personal favourite of Jens's. Mr. Bemba was, of course, the only accused before the ICC who was a man of means whose assets were frozen. But this needs looking at. You can't freeze somebody's assets for 10 years. You can't freeze anything for 10 years. You can't put a chicken in the deep freeze and expect to get it out 10 years later and it to taste very nice. You freeze somebody's assets for 10 years, you decimate them. Luke, you were very optimistic that Mr. Bemba's assets would have meant anything to the victims. They wouldn't. There's an aeroplane there. That is actually Mr. Bemba's aeroplane. It was parked at Faro Airport in 2008. The OTP took the keys. The registry took the airworthiness certificate, and it's still there. It was worth $5 million at the time. I don't know if you know anything about aeroplanes, but
I think he went to Congo with the plane.
maybe, but it's at Faro Airport now, and the OTP have the keys and the certificate of airworthiness. Once an aeroplane has had no certificate of airworthiness for 3 years, it's scrap. So that's a $5 million aeroplane that's now worth $250,000. It gets worse, of course, because it had flown in from the Congo. Once it had been there for a year, it was deemed an import, so VAT was liable on it at 20%. And it's been parked at an airport for 10 years, and you can imagine what the parking charges are. The defence did suggest to the registry way back in the day that it should be leased and that the proceeds should be placed in an escrow account to pay Mr. Bemba's legal fees, with the excess set aside for reparations to victims. But the court refused that. And so, just to pick that one example, a $5 million aeroplane is now something like a $25 million loss. If you're going to freeze people's assets, you become trustees of them, and you have to act as trustees. You have to manage them. There should be regular accounting meetings involving the defence as to what happens with frozen assets. Otherwise, the process is pointless. So I'm going to finish now where I think Lorraine finished, which is that the Bemba case is a wake-up call. I'm prepared to give the institution the benefit of the doubt that at the moment it's just hitting the snooze button. But it would be a tragedy if the ICC, in the light of everything there was to be learned from the Bemba case, turned the alarm off, rolled over, and went to sleep. Thank you.
Thank you, Peter, very much for this illustrative. I never thought that you would hold back your thoughts as a defense lawyers with regard to Bemba. But it's also very helpful that you shared your views as a legal representative for victims at the Special Tribunal for Lebanon. Now I will pass to Carla, who is going to talk about the future of reparations at the ICC, thoughts about effectiveness, impact, and the accountability of institutions. Thank you.
Thank you very much, and it's a great pleasure to be here. Last on the panel of presentations, each and every one of them started a bunch of ideas swirling in my head about what I should respond to, what I should agree with, what I should vehemently disagree with. But I think what I'll try to do is just put a few comments down and not go too long, because I think we're quite a bit over the mark. Looking at the future of reparations, of course, I have no crystal ball. We don't know what the future of reparations is. But in terms of how the rest of the panelists have framed the process up until now, I would say that I would agree that the process up until now has been bleak. I would probably go further than the somewhat muted responses of some colleagues to say that in some respects the reparations process has been quite shocking in terms of its lack of result. In the majority of cases, reparations has been so delayed. Looking at why that is, there's a range of different protagonists which we can look at in terms of roles, responsibilities, etc. But the fact remains that the average individual, regardless of the case, whichever case we're talking about, hasn't received reparations. Things are getting better slightly, but I think we're not where we need to be. There's a lot of people in different units, organs, with different roles, rushing around doing everything they can to push forward reparations. But I sometimes wonder, are we running around in circles? Are we actually working towards a goal? Are we all working on the same page? Are our results going to get us there? The statute is very cumbersome. The procedure has become very cumbersome as a result of orders of the court which have gone in a variety of different directions, perhaps not with so much foresight. But as a result, the process has become very labor-intensive, technical, difficult, and I don't know that without a big step back, one is actually going to get to where we need to go with reparations. With respect to the delay, I would probably say some of the big challenges at the beginning were the delays with the court decisions. Luc Rollin has already mentioned the amount of time it took to get the appellate decision in the Lubanga case is just shocking. 3 years? It's a shocking delay. But then I do also think we need to interrogate quite carefully the role of the trust fund in terms of how the trust fund responded to the orders of the court with respect to implementation of reparations. The court made it very difficult for the trust fund to proceed, and the trust fund was not in agreement with the court. But if one reads the filings in the Lubanga case that Luc made mention to, they go back and forth for a very long time. When parties needed to come together and talk it out, work out a solution, the court process didn't really enable that. And as a result, you had a lot of very unhappy people and a lot of time being wasted. It's probably fair to say that the trust fund's assistance mandate has been implemented with greater success than the enforcement of court-ordered reparations. But I think we need to interrogate that as well. In how many situation countries has the trust fund's assistance mandate been operating? Uganda, Democratic Republic of Congo, Ivory Coast, I'm not even sure. It did an assessment mission. I don't think it ever even got there. What about Kenya? Victims in Kenya for years have been requesting the court to go, to the trust fund to go to carry out missions. Never happened. So I think we need to look at that type of process as well. In terms of the challenges that Luc mentioned in relation to the orders of the court being difficult for the trust fund to implement, sure, they were difficult to implement, but that needs to be dealt with. One needs to figure out a way in which for the trust fund to deal with court-ordered reparations and deal with the identification of victims, either itself or in collaboration with others, which has started to happen, which I think is a positive thing. A few general points on effectiveness, impact, and the accountability of the ICC itself. And I think I'll start with the last thing, the accountability of the institutions. Accountability to whom? To the funders of the ICC, to the Assembly of States Parties? Of course, but also to its purpose, to its mandate. If the institution doesn't stand up for itself and see itself as a goal-oriented institution, then I think we also have a problem. Accountability should also be to the stakeholders of the process, to the victims, the defendants, the states impacted by certain proceedings. And I think we can see all of this to an extent, in terms of human rights accountability. The Article 21 of the statute references internationally recognized human rights as part of the applicable law before the court. But the framing of this provision is rather limited. The application and interpretation of law must be consistent with internationally recognized human rights principles, so the court is obliged to interpret its law in a manner that safeguards human rights. While this is somewhat important, it's different from and arguably a much weaker formulation than, for instance, recognizing that the various organs of the court are bound to respect the human rights of those persons impacted by their decisions. I question whether or not the court should seek, at least as a matter of principle, to achieve that, though. Even though 21.3 is limited, the ICC as an institution should see itself as seeking to respect and uphold the human rights of all those who who are party to its system. It already happens with respect to defense rights to a degree, not always very well, but there is a recognition that the court must ensure a fair trial for defendants. But does it exist with respect to victims? I would say not, and I think that is at the heart of the problem that we have with respect to the laissez-faire approach that we take to victim participation and reparations, because it's no one's fault if reparation doesn't work. That is the heart of the problem. The court has to take responsibility for creating a system that's going to work. Lots of people involved in this process, it's not working. Who's gonna fix it? Who's gonna fix the system? I think that's where we've got to start. 3 areas that I think require fixing, and many of those on the panel have already mentioned a range of them, many of which I agree with. But the first one, in my view, which is central to victims, and it's really about victim participation, but it has a clear role for reparation. And I would disagree strongly with the suggestion that one should limit victim participation. I think victim participation, we have to recognize that these situations are extremely complex. We want to have as much victim participation as possible. Then we need to talk about how can we do it when there's a huge number of victims. How do we do it? We must do it differently. But the area which impacts reparation the most is the ability for victims to intervene at the very early stages with respect to the decisions of the prosecutor about what to focus on, what not to focus on, and the decision to take forward or not a particular investigation or prosecution. If victims had the ability to engage with the court in a meaningful way at the early stages, this would be the most important way in which to feel part of the justice process. For a variety of reasons which we don't have time to go into, that isn't happening. For a mixture of how the statute has been interpreted, the extent to which the prosecutor has discretion, but also the limited procedural rights for victims in the early stages of proceedings. But secondly, from a human rights perspective, I think it's really important to recognize that victims have a right to speedy justice. So undue delay is not only about defendants' rights, but it also impacts on the conduct of reparation proceedings. So there's a need to recognize victims' rights to an effective remedy without delay, including reparations. So it's not simply, and it's no longer just unfortunate that the process is taking so long and going around in circles. It's not unfortunate, it's a breach of victims' rights. And the sooner we recognize that, the sooner we can work towards trying to fix the problems with the system that are causing these blockages. And the sooner that can happen, reparations has a better chance to be effective and to have real impact. Third point, and this is something that Lorraine mentioned very briefly, which I would agree with, which is positive complementarity in respect of reparations. Even if the court was able to mount the best possible reparations program for victims at the conclusion of a case, it would always be only a part of the puzzle. So finding a way for the court to engage with the state or states concerned on reparations matters would be really important. The Office of the Prosecutor at the very earliest stages has discussions with states when there is information about the commission of crimes. The Office of the Prosecutor is obviously not the right vehicle to deal with states on reparations, but the moments when there's some consideration of crime in the context of a preliminary examination, that's when the registry or other vehicles of the court should start engaging on, well, what's happening domestically in relation to reparations. That's when civil society groups in the country concerned can, at a parallel moment, start thinking about, well, let's get a reparations process to match and to take the synergy from the ICC process so that these things happen synergistically at the same time. I think I'll stop there, but just to say, I think the ICC and reparations is at a very difficult moment, but we shouldn't think that all hope is lost. There's a lot that can be done. These are not intractable problems. These are problems that can be fixed. Nothing is too difficult, and I have every faith in the great people at the court to be able to make the necessary changes in order to have the system work effectively.
Thank you, Carla, for concluding with your rather optimistic note on the reparations for victims at the ICC. I know we are running a little bit behind schedule, and that's an understatement, a little bit, but we will spend the next 15 minutes for questions, 15 to 20 minutes for Q&A. Who wants to start first? Yes, please.
Hi, thank you all for your talks. I've wrestled a lot with this idea of untethering or uncoupling reparations from convictions, and just play the cynic for a moment. And anyone can answer this if they'd like. Doesn't this create a danger if you pay reparations in advance of a conviction? Does this create the danger of the court being accused of paying people for their participation? And does it also create the danger, as Peter alluded to, some people are only interested in reparations. Do you then lose them from participation if you pay them in advance? Is there a danger of approaching the system from this direction?
I would say one needs to think about, when you talk about payments, whose money? And I think that in a way has something to do with it to an extent, because if you're talking about someone's assets who have been frozen and those are used to pay before a conviction, that might be somewhat problematic. But normally you're talking about a trust fund who's raised voluntary contributions, and it's those voluntary contributions which would go to the assistance framework. Oh, sorry. I think I speak loud enough. But just to repeat briefly my comments, that I think it has a difference depending on the source of funds. That if it's voluntary contributions, you don't have the same issue as if it was funds which were forfeited or frozen from an accused person prior to a conviction.
No, I was just going to say, if you look at the title of this panel, it is, after the Bemba Acquittal, the future of reparations for victims at the ICC. And I think we're pretty much unanimous. You've got to try something different. It may well be that advanced involvement of the TFV and commencement of a reparations process at the very beginning may have its flaws, but it can't be worse than what's just happened.
In a similar vein, just to pick up on the unanimity of all of you with respect to something requiring to be done at an earlier stage. My question is just whether the panel has any concerns with respect to decoupling the reparations from the process, from the participation process, and addressing reparations at an early stage, with respect to findings of fault that may be inherent with respect to the conduct of states or state policies by individual states which have not consented to ICC jurisdiction, and whether the suggested way forward risks, in the panel's view, any prejudice with respect to the monetary gold principle.
I wanted just to maybe react on a few things that I have heard, just because I don't think that everybody is clear enough, in my view, on what we are discussing here. And I tend to agree generally on a lot of things that have been said today. I strongly disagree on something. I will arrive to that in 2 seconds. I think that we need to understand that when we use the word reparations in the Rome systems, this word is attached to a conviction. So we cannot use the word reparations if we are talking of a Rome state system disconnected from a conviction, which is, by the way, the reasoning of a trial chamber in discontinuing the reparations proceeding in the Bemba case. So I think we need to tell to each other that we need to use probably another word, particularly if we want to disconnect the possibility for victims to be repaired somewhere of the harms they have been suffering from, independently of the conviction. And I take the suggestion of Peter. Let's discuss on one side the conviction, and on the other side how victims can be helped, supported, assisted because of the harms they suffer from, because for certainly they were victims in the situation in the Bemba case, independently of the conviction, and everybody recognized that. But then I think we have 2 options. One is we change the text of a court, which it's probably, in my view, the most reasonable way to go. Or we decide to completely change the way in which victims can receive some compensation because of the harm they have been suffering from. And in this context, I think everybody agrees, the trust fund may have a huge impact. But I want to recall that the assistance mandate of a trust fund is actually confined to 3 things: physical rehabilitation, psychological rehabilitation, and social assistance. Do these 3 things are sufficient to cover the extent of all the possible harms suffered by someone? This is exactly the reason why we have the assistance mandate and the reparations mandate. So I think we need also to put maybe some thoughts on the fact how to enlarge the role of a trust fund, but not limiting it only to the assistance. And my third, in a sort of brainstorming session, I was particularly touched by Peter's observation in relation to the fact, should we limit it or not, the participation of victims. I strongly disagree. Because, and I take the point, in the Tribunal for Lebanon, 72 victims. Now, apart from the fact that I don't think that we can really draw the parallel between the Lebanon and the ICC because of the scope of the type of crimes that we are dealing with, but apart from that, now in my experience, I have been representing victims before the ICC in the last 15 years. And the number of victims that I have represented in different situations and cases is a little bit more than 30,000. So I think that I know a little bit of what they think or not think about participating. Now, my experience is that the majority of them want to participate in the proceedings before the ICC because for them it's the only credible effort of getting justice. So you will probably be surprised to know that some of my clients are not even interested in the reparations. I have clients in the ongoing case who already told me, listen, I just want my voice to be heard in courtroom. I don't want reparation because what I have been suffering from, it's irreparable. And the last point is in relation to the fact how on earth you can represent thousands of victims. Now, I frankly, and I join the voices in relation to the fact that we need to find ways of doing it, it's an issue of organization. I mean, in the ongoing case, I'm at present representing 1,569 persons. I know each of them. I met each of them. And why? Because we have a team of people in VA, we have a team of people in the field, and the persons in the field are only dedicated to the contact with the client. We have a dedicated phone number 24/7. So there are ways, as you also illustrated with WhatsApp groups, of doing it. But maybe it's a matter of understanding how much resources are needed in a legal representative team to do the job. And I can go on, but I'm sorry.
Can I just, oh, sorry. Julianne, did you want to say that? I just wanted to add something to Paulina's comment about resources, because it's a very real issue. I think the understanding of the scope of reparations and what it really entails is something that perhaps we hadn't introduced in our discussion, but when we spoke about the responsibility of individual states, there is also a broader overarching responsibility for states parties to the ICC who are responsible for resourcing reparations, resourcing the trust fund, for example, ensuring voluntary contributions to the trust fund. I think if we are going to have a discussion about decoupling or delinking of reparations from a conviction, this is also something that would need to happen at the level of the Assembly of States Parties. And I understand, I haven't read it myself yet, but for example, the Committee on Budget and Finance, which is a subsidiary body of the Assembly that addresses financial matters, also needs to be educated about what this could entail. So for example, I give you a very classic example in relation to the legal representatives for victims in the Bemba case. The CBF does not see a need for an extension of their mandate in light of the ending of the reparations process. But it doesn't take into account that the Trust Fund for Victims has announced an assistance, the beginning of an assistance mandate in the Central African Republic, and that implies that the legal representatives for victims who have been engaging with their clients over the years would need to assist the trust fund in getting things up and running. So I think this debate also has to happen at the level of the Assembly of States Parties in order for it to move forward.
Just a quick question. I wonder whether in your varied and extensive experience there are national practices or courts or institutions doing it elsewhere which support this concept of an untethering that can be drawn upon to assist the ICC, and if it's considered to be the right thing, how that untethering could be perhaps supported or looked upon from examples elsewhere. Is there anything we can draw on?
Of course, in domestic systems you have such situations where, for instance, after give an example of a big train accident in Belgium. The responsibilities were very difficult to establish, but a fund was created to compensate the victims, not just assist, really, to pay compensation, to make an assessment of each individual harm and to pay the amount. And some insurances contributed in it, advancing money and so on. And at the end, the court will decide who will be responsible and for which part of it. It's also linked to another problem with the ICC, that the system not only links reparation to a conviction, but it even links it to an individual, where you have crimes, it's almost a general rule, committed by a common conspiracy of multiple actors, like you have Lubanga and Taganda and even others from UPC. There was a joint criminal responsibility for the recruitment of children. So the harm of those children is not different if they were recruited by Taganda or by Lubanga or one of their other commanders. So you can determine on an objective base what the harm was of this event, and later on decide what will be the participation of each person that will be convicted in it. And it's not préjugé, it's not prejudging the responsibility of X, Y, Z if by doing so. I don't think that it needs to redraft some provisions of the statutes or the rules. Probably it would be sufficient to adapt the regulations of the trust funds, which is finally the responsibility of the board of the trust fund with approval of the Assembly of State Parties. But I think it's maybe not that difficult to review this and to make it possible not just to assist. Indeed, now assistance is limited. You cannot reconstruct buildings in the framework of assistance, but it could be expanded, and it doesn't mean that reparation in the statute are strictly linked to a conviction, because the statute is not regulating the general mandate of the trust fund. The statute is only made to organize the judgment of the persons held responsible. So from the view of these persons, it doesn't make a difference.
It's a long time since I've done one, Jill. Oh, sorry.
Another example might be the Criminal Injuries Compensation Board. Sorry, can I finish? Thanks so much. But that would be delinked from a need to have a conviction. You will also have a lot of processes which never, reparation processes which never were coupled with a criminal process. So from that perspective, a criminal process doesn't necessarily need to precede it. But I would think also with respect to the trust fund, I can see the assistance mandate being expanded to have reparations predate the conviction would require a real massive change. And I think we could debate positively and negatively whether that is needed. But the assistance mandate to have a bigger role, I think, would be possible. But one issue in the regulations of the trust fund, there is a provision which says that whenever the trust fund wishes to intervene on its assistance mandate in a way that comes close to the case, it has to seek permission. Up until now, the trust fund has been very modest in that, and it's basically avoided providing assistance to any victims who are close to the criminal case, which is kind of interesting in that respect. So if you're a victim of Mr. Lubanga, the child soldiers, trust fund would go around you to the wider victims, but not focus on you yourself because of the criminal process that's going on. So that would need to be looked at in relation to any expansion of the assistance mandate, how the trust fund applies that provision.
Well, I think we're done, right? Thank you, everyone, for this very insightful and thought-provoking discussion on the reparation issues for victims at the ICC. May I kindly invite you for 15 minutes coffee and tea break, and then we will resume here with the second panel. Thank you.